So, ladies and gentlemen, good morning. Let me first of all say thank you to Professor Eric Frank and Dr. Marco Benatar for, first of all, having organized this very important event, and also for having invited me to chair this panel on navigational issues. This morning, Professor Frank recalled the Institut de Droit International. I come from Napoli, the city that gave 2 of the 11 founders of the Institut de Droit International, Emilio Pierantoni and Pasquale Stanislao Mancini, the first president of the Institut de Droit International. So up to 11 members, 2 came from my city. It's quite an important success. I also come from a university, University of Napoli, L'Orientale, which was the first one in Europe to have a link with Chinese students and Chinese scientific world. It was called the Chinese College in the 18th century when it was founded. So we have kept a particular link and interest with all what happens in Asia. And thirdly, in my capacity of President of the International Association for the Law of the Sea, may I recall that it was here in Brussels that 20 years ago, the late Professor Daniel Vigne, I am happy to remember him here with you, had this idea of founding an association with 2 young professors at this time, me and my colleague Rafael Casado Raygon from Spain. And now this association is going on with quite a good success. We hope to go on to improve it with new members and new activities. Now, we have to speak of navigation in South China Sea, in Eastern Sea, according to another way to call it. As you know, as it has also been said, according to United Nations Convention on the Law of the Sea, we can range it amongst the so-called semi-enclosed sea, which, first of all, always according to UNCLOS, have to be managed with a stronger cooperation between states that are on these seas. And another point to remember, South China Sea connects Pacific Ocean and the Indian Ocean through the Spratly Islands and through other numerous islands and reefs spreading throughout sea lanes. So it is quite an important area, as always been, has also been said, in which UNCLOS rules and also post-UNCLOS rules, may I say, because as we know, customary law has gone beyond in some aspects to UNCLOS rules. UNCLOS and post-UNCLOS rule find a sort of laboratory very, very important, very, very interesting for scholars and for everyone who is interested to law of the sea issues. And, of course, for what concerns navigation through territorial seas. And may I recall that according to Chinese declaration at the time of ratification of UNCLOS, according to China, warships have to obtain an authorization in order to pass through their territorial sea. This is one of the difficult points at stake, because according to UNCLOS and according also to international practice, all ships have the right of innocent passage. A sort of evolution came concerning nuclear ships, concerning dangerous ships, in the name of the interests of the international community. May I recall the Bamako Convention and other documents of this kind. But for what concerns the passage of warships, in my opinion, and not only my opinion, nothing has changed from the time of the convention in the freedom of passage. But anyway, China is not the only state, as we know, that asks for permission. For what concerns EEZ, also navigation rights in the EEZ, there are some problems. There is a sort of interpretation of China of these navigational rights, which is, may I say, too much linked to the interests of the coastal states. May I recall that EEZ is the meeting point of coastal state pretensions and general interests of navigation. And of course, other problems like archipelagic sea lanes passages, archipelagic passage, which according to UNCLOS is only a right for archipelagic states to adopt, not for states who claim sovereignty on archipelagos. This is different, who has or who have sovereignty over archipelagos. A state must be an archipelagic state in order to adopt archipelago lanes. So there are many issues at stake. Of course, also the question of passage through straits. Is the situation, according to customary law, different from UNCLOS provisions? Because straits have always to be free for navigation rights, or sometimes for environmental reasons, coastal state can in a certain way limit this passage. This is an important also aspect if we think to important straits which of course are in this area. And of course there is another question, the question of air defense identification zones, so the parallel, the relationship between sea passage and air passage. So there are many things, but of course I have to stop here and not abuse of my position as chairman. And so we have this very interesting, important panel. And the first speaker is, I have the pleasure to introduce Professor Keiwan Zhou. Professor Keiwan Zhou is Harris Professor of International Law at the Lancashire Law School of the University of Central Lancashire in the United Kingdom, and also a visiting chair professor at Guanghua Law School of Zhejiang University in China. So he can offer a point of view, different point of view of different continents on the issue. He specialized in international law, and in particular law of the sea, international environmental law, published over 60 referred English papers in many international journals. In particular, may I recall the book Law of the Sea in East Asia, Issues and Prospects. So, Professor Zhou, the floor is yours for about 25 minutes.
Okay, thank you, Mr. Chairman, for your kind introduction. And first of all, I would like to express my gratitude to the conference organizer, particularly Professor Eric Franks, for his invitation. And also, I am very pleased to come here to meet old friends and also new friends. It is quite an important conference, as it is also already mentioned in the introduction session. And we can see that in Europe, we have several, I think, conference on the South China Sea. But this one is particularly focused on international law. That is, to my knowledge, is the first one, particularly on international law, because the conferences I attended previously, they have various academic, various disciplines, and this is the majority of the speakers or participants from the legal field. So, kind of indication of legal professionalism. My topic today is also, it is the assigned topic about navigation in the South China Sea. I feel very regretted that James is not here, because there's no fun without James. And navigation, the navigational issue in the South China Sea is actually the issue between China and the United States, not a real issue between China and other countries adjacent to the South China Sea. And then we look at some introduction, just as we know that the chairman already introduced, the South China Sea is a semi-enclosed sea, and also it's a critical sea route for global trade and communications. And there's a figure and in my slides, and a lot, quite busy sea routes for trade and communications. And also but on the other hand, South China Sea is also fishing sport, and there's territorial and maritime disputes, and also maybe a potential conflicts with various different national interests, because we can see from time to time that there's reports in mass media, the incidents, and even quite recently, the reports saying some incidents reported by the Philippine media, China's kind of aggressive activities there, like the land reclamation over some reefs and tiny islands. And so the safety of navigation remains an issue. There are two aspects. One is because there are sea routes, critical sea routes, so the South China Sea is essential for world seaborne trade. And the other is because there are maritime disputes and territorial sovereign disputes, so this could constitute a threat to the safety of navigation once all these disputes and the tensions escalated, possibly to an armed conflict, or otherwise there could be a threat to safety of navigation. So the navigation in the international context, and also the freedom of navigation, this is the principle of international law for centuries, and but it is first incorporated into conventional international law. Was in 1958, when the 4 Geneva Conventions on the Law of the Sea were adopted. So at present, the navigational rights of vessels are mainly governed by the Law of the Sea Convention, which was adopted in 1982 and came into force in 1994. Then the Law of the Sea Convention has made a legal arrangements for navigational rights of foreign vessels in accordance with different sea zones established under the convention. The sea zones like territorial sea and the exclusive economic zone, the EEZ, are particularly related to navigational rights of foreign vessels within the national jurisdiction of a coastal state. Then there's the right of innocent passage. This is a quite familiar term to most of the people at the present, and also the freedom of navigation is easy. Then the due regard, that means when you exercise this right of navigation in the EEZ, and you are obliged to pay due regard to the rights and obligation rights of the other countries, including the coastal states. Then move on to the Chinese regulations, and we can see that some this is a partial list, and we can see that the law on the territorial sea and the contiguous zone, this was adopted in 1992. Then the second one is law on the EEZ and the continental shelf. This was adopted in 1998. Then the law on maritime traffic safety. This was relatively earlier in 1984. Then regulations governing supervision and control of foreign vessels. Then the regulations governing non-military foreign vessels passing through the Chongzhou Strait. This is only governing the passage through a strait within the Chinese national jurisdiction. Then there will be some details. Foreign ships for non-military purposes enjoy the right of innocent passage through Chinese territorial sea. Then the second one is foreign vessels used for military purposes are subject to the permission from China before entering the territorial sea. And the foreign submarines and other underwater vehicles, when passing through the territorial sea, should navigate on the surface. This is in conformity with the law of the sea convention. But the second point is kind of maybe it is debatable and controversial whether it is in line with the provisions under the law of the sea convention. So then in 1996, when China ratified the law of this convention, China re-emphasized its position on innocent passage. Then the provisions of the UN Convention on the Law of the Sea concerning innocent passage through the territorial sea shall not prejudice the right of a coastal state to request, in accordance with its laws and regulations, a foreign state to obtain advance approval from or give prior notification to the coastal state for the passage of the warships through the territorial sea of the coastal state. So here the problem in terms of China's domestic regulations is, according to the 1992 law on the territorial sea and the contiguous zone, China only provides the prior approval and the prior the advance, the permission advance for the passage of the foreign warships. But here, China listed two conditions. One is advance approval, or the other is prior notification. So it is not, after that statement, it is not clear whether China approve the permission, or approve the passage of the foreign warships, or just the foreign country just give a prior notification to the Chinese authorities when its warships passing through the territorial sea. So it's conflicting. There's no official explanation about this. I don't know. Maybe there's a discretion in the hands of the Chinese authorities to decide which country need approval or which country just give prior notification. Perhaps in the United States, just to give prior notification. This is my own guess. Then follow the Chinese regulation. This is the EEZ and the continental shelf law. Foreign vessels, including warships, can enjoy the freedom of navigation. And in China's EEZ, provided that they comply with the relevant Chinese laws and regulations, as well as international law. So this is the kind of general provisions and following the law of this convention. Then the Chinese EEZ law provides that China should have the right to take necessary measures against the violations of Chinese law and regulations, and to investigate according to the law those who are liable and may exercise the right of hot pursuit. So the hot pursuit, the right of hot pursuit is reserved in China's EEZ. So then move on to the military activities in EEZ, because some countries, particularly United States, argued that the military activities in the EEZ is part of the freedom of navigation. Then we can see that the military uses usually consists of two categories. It's the movement rights and the operational rights. And the former embraces the notion of mobility and the transit passage, innocent passage, and high freedom and navigation and overflight. The latter includes activities such as task force, maneuvering, anchoring, intelligence collection, military exercises, etc. So this is kind of two categories. One is movement rights and one is operational rights. Then we can say that some states may invoke Article 58 of the law of the Convention to justify their military activities in other countries' EZ. And this is the article reads, the exclusive economic zone, all states whether coastal or landlocked enjoy, subject to the relevant provisions of this convention, the freedoms referred to in Article 87 of navigation overflight and other international lawful uses of the sea related to these freedoms, such as those associated with the operation of ships, aircraft, and submarine cables, and pipelines. And according to maritime powers, such as the United States, the term freedoms associated with the operation of ships, aircraft, implies the legality of naval maneuvers in the following EZ. This is the U.S.-American position. Then, according to the then there was a group called EZ21, and they drafted guidelines after a series of workshops, mainly funded by the Japanese Foundation and Nippon Foundation, and initiated by the East-West Center in 2001, just after the EP3 incident between China and the United States in the South China Sea. So the guidelines just give some advices to how to manage the military activities in the following EZs. So this one is ships and aircraft of a state undertaking military activities in the EZ of another state have the obligation to use the ocean for peaceful purposes only, and to refrain from the threat or use of force or provocative acts, such as stimulating or exciting the defensive systems of the coastal state, collecting information to support the use of force against the coastal state, or establishing a sea base within another state's EZ without its consent. Then the user state should have due regard for the rights of others to use the sea, including the coastal state, and comply with its obligations under international law. So this is the one. Then last year, in April last year, and at the 14th annual conference on the Western Pacific Naval Symposium, the symposium, the navies, they adopted the Code of Unplanned Encounters at the Sea, the CUES. So the CUES is very important. Of course, it's not a legally binding document, but it is a kind of guideline to be followed by the Pacific navies. Then there was a report recently that just last month, on 23rd February 2015, one U.S. warship and with the Chinese warship, the two warships conducted routine training and operations in the South China Sea. So that kind of joint exercise definitely can enhance the professional maritime relationships between the American side and the Chinese side. It seemed to me that because of the dialogues and the Chinese, the two sides, they try to narrow their differences. So next month I will go to Washington, D.C. To participate in the Track 2 conference on the maritime security between China and the United States. So they try to narrow down all the differences and work out implementing a plan to avoid collisions and confrontations at the sea between the two navies. Then in conclusion, military activities, except the exercise of the right of navigation overflight above the EZ and the law of the Sea Convention, are not navigational rights per se, but special rights associated with the navigation. It should not take for granted that since such activities are navigation associated, they be treated equally as navigational rights. This is my personal view and subject to discussion and counter arguments. And some issues related to navigation in the South China Sea, and also mentioned by some scholars like Professor Eric Franks. And the first one is the U-shaped line. And the U-shaped line this is the U-shaped line, and you can see this is a 1948 map. And there's originally it has 11 segments, and in the 50s, in the early 50s, in the middle 50s, and the 2 segments in the Gulf of Tonkin were removed by the Chinese government without explanation. And so nowadays it is commonly called 9-dash line. So this is a 9-dash line. It has implications for the safety of navigation in the South China Sea. And this is the map China submitted to the United Nations in 2009. And there's some differences, you see, and I don't know. This is the original map prepared by the Republic of China and before the People's Republic of China in 1947, and publicized and to the public, publicized in 1948, but it was drawn in 1947. But this one is submitted by China in 2009, and some people query the inaccuracies of this map according to the original map in 1948. Then evidence shows that the Chinese maritime law enforcement extends to the whole ranges of the U-shaped line. That means when they exercise some law enforcement activities in the South China Sea, they just follow regarded the U-shaped line as a range of their exercise and law enforcement. While the free navigation in the South China Sea is not hampered by the Chinese maritime law enforcement forces, some activities associated with marine resources exploration or with consolidation of territorial and maritime claims are disrupted. So we can see some incidents here, and this is evidence to show that China's law enforcement extended to the gems show, gems show in the South China Sea. That is, and also another incident which happened in 2010, and this is the fisheries management law enforcement forced the Indonesia warships to release a detained Chinese fishing vessel in the sea area 57 nautical miles to the Natuna Islands, where Indonesia claims as its EEZ, but China refuses to recognize. Then in the memorial of the Philippines submitted to the Arbitral Tribunal in March last year, the Philippines accused Chinese vessels of threatening Philippine vessels in the vicinity of Scarborough Shoal, Scarborough Reef, by engaging in highly dangerous maneuvers that had caused serious risks of collision, and China had thus violated Article 94 of the Law of the Sea Convention, and colleagues is the Prevention of Collision in the Sea Convention. And then there's a very interesting term in Chinese legislation called other sea areas under China's jurisdiction. And then, because after China ratified the law of this convention, we can see that the sea zones, just the internal waters, territorial sea, EZ, and continental shelf, but within national jurisdiction, there's another zone in Chinese legislation called other sea areas. So what is other sea areas? Then it is believed to refer to the waters within the U-shaped line, but it is not clear how China treats such other sea areas. It is treated as territorial sea or EZ or otherwise, but there's no clear explanation ever given by the Chinese side. So we don't know. This is a kind of puzzle in China's legislation. And also the second issue, related issue about with navigation is China designated 3 military zones: the military alert zone and the military prohibited navigation zone, and also the military operational zone. And all these zones were designated in the 1950s, and also and just after the Chinese Civil War, and for the purpose to take over Taiwan, called liberate Taiwan in Chinese term. But these zones first appeared in the 1962 Chinese and Japanese non-governmental fishery agreement. And even in 1987, the Chinese and the Japanese fishery agreement, these zones are already were still there. But in 1997, when China and Japan concluded a new fishery agreement, these zones were disappeared, not mentioned, attached to the agreement. So we don't know whether these zones still exist or dormant. Just maybe, in my personal opinion, it's just dormant. It's not mentioned, but when there's something, for need, then the zones could be revived in a later time. And the zones, this is then the third issue is about the straight baselines. And China encircled the Seaside Islands, the Paracel Islands, in 1996 by straight baselines. This had brought a protest from foreign countries like the United States. And this is a map of the baselines of China, and you can see there's a small because in the South China Sea there's a encircled the spread Paracel Islands were encircled by the straight baseline, and so according to the United States, China would not be allowed to establish archipelagic straight baselines around the Paracel Islands because China is not an archipelagical state, and the Paracel Islands are not an archipelagical under the definition of the Law of the Sea Convention. And despite the controversy over China's straight baselines from the Paracel Islands, for the Paracel Islands, foreign vessels can enjoy innocent passage under the Law of the Sea Convention within the waters encircled by China and treated as China's internal waters. Okay, then some conclusions. And the first one is China and the US need to work out guidelines for their naval encounters. Of course, they are just towards that direction. And the issue of military activities in EZ is not an issue only between China and the US, but a concern with most of the adjacent countries to the South China Sea, like Malaysia and Vietnam. They are all opposed to the military activities in their EZs. Then the second conclusion is there should be a caution for foreign vessels navigating through disputes waters due to the unclear maritime boundary delimitation between China and its neighboring countries. If there's a tension, conflict between claiming states in the disputed areas, then the normal navigation would be unnecessarily hampered. Then finally, China and its ASEAN counterparts reaffirmed their respect for and commitment to the freedom of navigation in and overflight above the South China Sea as provided for by the universally recognized principles of international law, including the Law of the Sea Convention. Then currently the two sides are preparing to work out the code of conduct, which is legally binding. So this kind of commitment should be reflected and incorporated in upcoming COC. So I stop here and welcome comments and questions. Thank you very much.
Thank you very much, Professor Du, for your extremely interesting presentation. I'm sure that there will be a debate, an interesting debate on it. Unfortunately, Professor James Kraska could not attend this meeting as has already been announced. Professor James Kraska is Professor of Oceans Law and Policy in the Stockton Center for the Study of International Law at the US Naval War College. But he also served for more than 20 years as a lawyer and commissioned officer in the US Navy, so he could give us both the practical and theoretical point of view on this issue. But anyway, he sent his presentation to us, and so we thank Marco Benatar for reading for us this presentation. The floor is yours.
Thank you very much. This paper is entitled Confidence Building Measures for Navigation in the South China Sea by Professor James Kraska, read by Marco Benatar. This contribution focuses on confidence-building measures to ensure navigational safety and security in the South China Sea. The United Nations Convention on the Law of the Sea, UNCLOS, and the International Regulations for Preventing Collisions at Sea, COLREGS, are the foundation of navigational safety and security. In 2014, these two global treaties were complemented by 3 non-binding agreements that were negotiated principally to avoid navigational incidents in the South China Sea and the East China Sea. The Code of Unanticipated Encounters at Sea, the so-called CUES, is a multilateral framework to enhance communication at sea and 2 Sino-American bilateral agreements, the rules of behavior and notification of military activities, which provide additional guidance. This chapter explores the new agreements and assesses their impact on navigational safety in the South China Sea. These agreements operate within a dynamic and increasingly unstable maritime environment. There is underway in the South China Sea a seismic shift in geopolitical relationships that reverberates from Delhi to Washington. The rise of China, and more precisely Beijing's assertiveness at sea, marks realignment in the balance of power in East Asia that is the counterpart to the emergence of a revanchist Russia on the continent of Europe. The relationships among Russia, China, and the United States form a tripolar world system. Moscow and Beijing now define their strategic interests in terms that is designed principally to stymie American hegemonic power in Europe and the Asia-Pacific region, respectively. While Europe faces a threat from Russian domination on land, uncertainty in Asia arises from China's emphatic maritime posture. Within this geostrategic context, international law may be a tool to increase stability and predictability for navigational safety and security. The regions of the world most at risk with threatened access to the oceans are the Persian Gulf, the East China Sea, and the South China Sea. The export economies of China, Japan, and Korea, and other Asian states are acutely reliant on the sea lines of communication for economic prosperity. Since its establishment in the 18th century, the United States has been a champion of freedom on the seas. The 2015 US National Security Strategy reiterates this historical doctrine, and I quote, "The United States has an enduring interest in freedom of navigation and overflight, as well as the safety and sustainability of the air and maritime environments," end quote. Freedom of navigation is a core interest of all states along the rim of the Pacific, but the United States and China have particularly strong and competing visions for how it should operate. Whereas the United States and its allies in Asia prefer a maritime order underwritten by dominant American presence, China appears intent on displacing the US role. In the modern era, China played a rather subdued role in the East China Sea and South China Sea. Until the end of World War II, the Chinese Navy was incapable of even reaching the Spratly Islands. On December the 12th, 1946, 2 Republic of China warships given to Taipei by the United States arrived at the tiny island of Ituaba. They removed the Japanese stele that had been erected on the island and raised the flag of the Republic of China. In 1974, as the US-backed government in South Vietnam fell, the People's Republic of China invaded and seized the Paracel Islands. In 2009, China resurrected its dashed line claim over most of the South China Sea. Emerging from a decrepit green and brown waters force structure just 2 decades ago, the People's Liberation Army, the Navy, has been on a construction binge that is producing a powerful and modern submarine and surface fleet that could outnumber the entire US Navy in just a few years. Last year, China began to construct artificial islands on features it occupies within the dashed line claim. At the same time, China has aggressively intercepted US and foreign warships and naval aircraft in the South China Sea. In just the most recent incident, in late August 2014, a PLAAF Su-27 fighter jet aggressively intercepted a US Navy P-8 Poseidon maritime patrol aircraft in international airspace. The Chinese jet made several passes at the US aircraft, crossing over and under it. At one point, the jet interceptor flew wingtip to wingtip and then performed a barrel roll over the top of the US spy plane. Deeply troubled by this type of demonstration, the US armed forces have invested in operational approaches to ensure unimpeded naval and aviation operations. The Joint Concept for Access and Maneuver in the Global Commons, the JAMGC, for example, explores how US forces can overcome the threat of naval mines, submarines, and surface and air contacts. Likewise, it is remarkable that virtually every state located in East Asia is pursuing an offset strategy to compensate for China's bid for regional hegemony. Hedging strategies by these states include a massive regional naval and air force buildup and diplomacy to forge new ties with old adversaries, such as Vietnam and India with the United States. Chinese operations related to its notorious maritime claims generate clashes with the maritime civil and naval forces of virtually every coastal state in an arc that runs from Japan through South Korea, Vietnam, and Malaysia, and states as distant as Australia and India. Every other coastal state along the South China Sea has rejected China and Taiwan's dash line claims. Only tiny Brunei has not publicly repudiated China's maritime claims. The coastal states are taking bolder steps to balance China. In September 2014, for example, Malaysia offered to host US Navy P-8 Poseidon aircraft on the tiny island of Labuan in East Malaysia. The island lies near Brunei, off the shores of Borneo. Located on the edge of China's expansive maritime claims in the South China Sea, use of the Malaysian airbase considerably broadens the reach of US Navy maritime patrol aircraft over the contested waters. The Malaysian offer is particularly significant because of its timing. The week before the Malaysian announcement, General Fan Changlong, the vice chairman of China's Central Military Commission, told US National Security Advisor Susan Rice during a visit to Beijing that the United States should, and I quote, scale back or completely halt, end quote, maritime surveillance flights near the Chinese coast. Instead, the United States expressed its resolve to continue the exercise of high sea freedom of navigation and overflight and other internationally lawful uses of the seas in areas beyond the territorial sea, and it is doing so in concert with other concerned states. The interests of all states in the Asia-Pacific region, including China and the United States, converge around the goal of conflict avoidance and war prevention. The bedrock international law authority for ensuring navigational safety and security are UNCLOS and COLREGs. In the Western Pacific, UNCLOS and COLREGs have been supplemented by additional non-binding multilateral and bilateral agreements. In April 2014, for example, regional states adopted the Code for Unplanned Encounters at Sea, the so-called CUES, to enhance safety at sea. Chapter 2, Code for Unplanned Encounters at Sea. CUES is a non-binding set of communication protocols to enhance naval safety and provide greater transparency among naval forces operating in close proximity. The code emerged from a meeting of the Western Pacific Naval Symposium in April 2014 held in Qingdao, China. The Western Pacific Naval Symposium is an informal body of navies that seek to increase cooperation and build confidence in the Western Pacific. The organization was established in 1988 and now consists of 21 member nations and 4 observer states. The group provides a venue for collaboration on issues of maritime security, information exchange, capability demonstration, and exchange of personnel. The 21 WPNS member navies approve the code as a way to facilitate navigation and reduce tension. The WPNS conducts biannual meetings to discuss issues of common interest to member nations, and it also conducts maritime exercises, such as mine countermeasure drills, office exchanges, and senior enlisted working groups and in environmental working groups. By doing so, WPNS seeks to avoid interference and reduce uncertainty in naval interactions through enhanced tactical information sharing and a recommitment to COLREGs. The code is not legally binding, and it does not supersede existing national instructions. Furthermore, it applies to armed forces and not civil authorities, such as marine law enforcement or national coast guards. It also was not intended to resolve the many territorial disputes of the South China Sea. The application and scope of CUES are set forth in Part 1. Part 2 focuses on safety procedures and emphasizes observance by all parties to the rules in COLREGs. Part 3 of CUES aims to simplify communication at sea by incorporation of a limited set of maneuvering signals based on NATO protocols. This clear set of sound, light, and flag signals does not require operators to use or understand English. The code is designed to provide a means for forces to communicate intent and thereby avoid an incident. The United States has supported CUES for nearly a decade, and the US 7th Fleet, forward deployed at Yokosuka, Japan, has used CUES since 2011. Beginning with its adoption by WPNS, however, US forces worldwide have integrated CUES into training and standard tactics, techniques and procedures, TTP. The means of communication and maneuvers in CUES provides pre-planned responses to encounters at sea that enhance existing TTP. The rules can limit uncertainty among naval forces and facilitate communication from naval ships and aircraft. Basic tactical and maneuvering signals included in the CUES annex convey to nearby foreign warships the intention to conduct formation streaming, turning, course, and speed. CUES also contain elected signals vocabulary and basic maneuvering instructions that include code word flag or verbal signal letter meanings, such as A or Alpha, to designate divers or explosive ordnance disposal personnel operating below the surface of the water, and B or Bravo to denote weapons practice or at sea fueling or transfer of explosive during underway replenishment. Submarines' pyrotechnic signals include red, yellow, white, and green signal flares. Red flares indicate an emergency. A submarine is in serious trouble and will surface immediately. Yellow or white smoke flares means a submarine is surfacing to periscope depth. Green flares are a submarine simulated attack signal. if anti-submarine units sight an unexpected signal other than green, they may assume an emergency surfacing of the boat. Chapter 3. Sino-American bilateral agreements. Even with cues, some scholars advocate additional agreements to build confidence and prevent incidents. Retired Australian Royal Navy Commodore Sam Bateman and retired US Navy Admiral Michael McDevitt, for example, have suggested the United States and China enter into an arrangement similar to the US-Soviet Union Incidents at Sea Agreement of 1972. Pete Pedroso has called this approach a bad idea, but Beijing and Washington already are moving in that direction. In November 2014, the United States and China signed 2 memoranda of understanding to prevent escalation of naval and air incidents. The Rules of Behavior for Safety of Air and Maritime Encounters and the Notification of Major Military Activities are bilateral agreements that supplement cues for the 2 great powers. The agreements are a result of more than 10 rounds of deep consultations between the 2 states. The MOUs were designed to increase transparency and predictability and reduce risk of unintended incidents. The question remains, however, to what extent can they really do so? The first MOU focuses on rules of behavior for safety of air and maritime encounters. The Rules MOU emerged from discussions between President Barack Obama of the United States of America and President Xi Jinping in June 2013 to diffuse a series of escalating encounters at sea and in the air occurring in the South China Sea and East China Sea. The rules reiterate the importance of UNCLOS, the Convention on International Civil Aviation, the Chicago Convention, call regs, and cues. Annex 1 of the rules contains general terms of reference, and it states that every flag state should take necessary measures to ensure military vessels flying its flag ensure safety at sea. State vessels, including warships and naval auxiliaries, as well as state aircraft, are recognized as enjoying sovereign immunity. The agreement also states that when naval vessels and military aircraft of one side exercise their rights, freedom, and lawful uses of the sea and airspace, they shall exercise due regard for the rights, freedoms, and lawful uses of the sea and airspace by the other side's warships and aircraft. This provision reflects Articles 58 and 87 of UNCLOS, but is not entirely clear whether the parties are in agreement on what it means. In UNCLOS, coastal states do not have any grant of freedoms in the EEZ as a coastal state, whereas other states are recognized as enjoying freedoms of navigation and overflight and other internationally lawful uses of the sea. Article 55 of UNCLOS is clear that the EEZ is subject only to the rights and jurisdiction of the coastal state, while foreign states alone enjoy rights and freedoms. Under Article 58, paragraph 2, other states are entitled to the freedoms referred to in Article 87 of Navigation and Overflight and other international lawful uses of the sea related to those freedoms, such as those associated with the operation of ships and aircraft. Thus, if there are encounters between US warships in the EEZ of China, the US vessels enjoy freedoms in that zone as a function of their US registered flag. Chinese warships also enjoy navigational freedoms in their EEZs, of course, but only as a function of China as a flag state, not at all because of China as a coastal state, exercising its sovereign rights or jurisdiction in its EEZ. In other words, the ships of both states that encounter each other in the EEZ enjoy the same rights of freedom of navigation vis-à-vis the vessels of other states. It is immaterial whether one state is the coastal state. The rules that govern the navigational encounter are no different than if it had occurred in the EEZ of a third state or even on the high seas. Annex 2 of the rules set forth behavior for safety of surface-to-surface encounters. The call regs are the governing legal regime in this regard. Military vessels that encounter each other should utilize active communications and coordinate their movements in accordance with the International Code of Signals, ICS, the radio regulations of the International Telecommunication Union, the standard marine communication phrases, as well as cues. The Annex 2 provisions, however, are rather perfunctory, such as requiring each side to respond promptly to calls by the other, to identify themselves, deliver professional and courtesy greetings, signal vessel maneuver intentions, and announce activities either planned or in progress that may affect the safety of nearby vessels. When warships encounter each other, they should maintain a safe distance to avoid the risk of collision. If a military vessel is restricted in its ability to maneuver, or ships from both sides are restrained in their ability to maneuver, they are to abide by the terms and spirit of Colregs. A single warship normally should give way to a formation or convoy. Activities that affect the safety of nearby warships and military aircraft, such live fire exercises and operational maneuvers, should be preceded by a maritime navigation warning area. Timely hazard warnings to ships and aircraft in the area and timely active coordination can reduce unintended force interaction. Warships and aircraft of one country should not interfere with the activities in a warning area declared by the country. Likewise, warships should notify nearby vessels or aircraft of activities that may affect their safety and coordinate safe standoff distance. Notwithstanding this provision, however, ships and aircraft from both sides enjoy freedom of navigation and overflight, and other internationally lawful uses of the sea associated with the operation of ships and aircraft. The rules implicitly recognize that as instrumentalities of the state, warships and military aircraft have sovereign immunity and a right of self-defense. The determination of this right is made on a case-by-case basis by the commanding officer of the units involved, who balance the potential threat from other military forces in the area against the right of those ships and aircraft to operate there. Warships and aircraft should incorporate into their operations the particular safety concerns that prevail in specific tactical and operational conditions, such as congested waterways and inclement weather. Commanders also must consider how their actions may be misinterpreted. Prudent commanders should avoid simulated attacks by aiming guns, conduct acrobatic flying, conduct unsafe approaches by small craft, or direct fire-control radar, torpedo tubes, or other weapons in the direction of foreign military ships or aircraft. Furthermore, the discharge of signal rockets or weapons in the direction of foreign warships and aircraft, unless done as part of a distress call, should be avoided. Finally, bright optical displays, such as illumination of the bridge of military vessels or aircraft, or the use of a laser in such a manner to cause harm to personnel or damage to equipment, should be avoided. It is unclear, however, exactly how far these prescriptions extend. Such conduct should be avoided, but the rules do not state that it is forbidden. One side may not, however, board the ships or aircraft of the other side without prior explicit consent. In case of collision, both sides should conduct damage control and search and rescue to preserve life and property, and the units should be separated. Situations that arise should be discussed through military and diplomatic channels, and existing, although so far fruitless, military maritime consultative agreement mechanism. Communications during encounters at sea include the use of sound, light, flag signals, semaphore, radio, and other means of communication under the ICS and the International Radio Regulation of the International Telecommunication Union. The format for military vessels is the name of the ship or hull number of the international radio call sign. Vessels and aircraft should also identify their nationality. Communication should be conducted in English, as required by the IMO standards and cues. It is preferable to use communications methods that are not dependent upon the spoken word. However, as plain language and verbal exchanges are susceptible to misunderstanding, instead, the parties agree to prefer the ICS phonetic alphabet and figure spelling and position code. Part B, notification of military activities. The second MOU, notification of major military activities, or simply notification, is designed to increase transparency of each country's security policies and strategies, and the legal approach that each side take with respect to the other. China and the United States agree to provide briefs, official speeches, major government publications such as defense white papers, strategy publications, and other official pronouncements. This exchange of views about major operations, exercises, and strategy is designed to bring greater transparency to the relationship. The notification also states that both sides, open quote, affirm their aspiration to establish a voluntary foundation for notifications of major military activities and endeavor to improve the scale and frequency of notifications gradually through consultations. The recognized channels for this exchange of notifications are national level ministries and agencies in Beijing and Washington rather than field level or operational fleet headquarters. An associated observation mechanism fosters mutual trust and transparency in military affairs. Both sides should extend invitations to the other to observe unilateral, bilateral, or multilateral military exercises or activities. It is not clear, however, how this rule is implemented in practice, since both sides are likely to be selective in making such invitation. The invitations should be reciprocal, and the parties anticipate that they will increase over time in terms of both quality and quantity. Both MOUs establish an annual assessment process. As a supplement to the notification, the United States has prioritized completion of a mechanism for informing the other party of ballistic missile launches. China has the most active and diverse ballistic missile development program in the world. In 2009, China and Russia reached an agreement for notification of impending ballistic missile launches. So far, however, China has been wary of a similar agreement with the United States, and launch notifications are not part of the new MOU. Part C, aviation encounters. This year, China and the United States intend to complete an additional annex that addresses air-to-air encounters. Disagreements over US reconnaissance flights in international airspace near China's coast, however, may be insurmountable. The PLA Air Force has been particularly resistant to freedom of overflight in international airspace off the coast of China. Only time will tell whether the antagonists sign such an annex. Chapter 4, Bilateral Statements. Several states in the region have released bilateral statements that underscore the importance of safe and free navigation. The United States and Singapore, for example, released a joint statement of February 13, 2015 that emphasized freedom and safety of navigation. The new agreements are a great way forward as far as they go. If they're implemented in good faith, however, they can reduce the likelihood of an incident among the most powerful and dangerous forces afloat and in the air. Perhaps the greatest shortfall in CUES and the bilateral instruments is that none of them apply to non-naval assets. Beijing employs a fleet of fishing vessels and other civil craft and Coast Guard ships to promote and enforce its maritime claims, and these lie outside the new agreements. Furthermore, there is an unenviable record of China signing non-binding agreements and then failing to follow through. For example, China's recent construction of artificial islands in the South China Sea is inconsistent with its commitment under the 2002 Declaration on the Conduct of the Parties in the South China Sea to exercise self-restraint in its activities that would complicate the disputes. While the path from middle to major power is never an easy one, China faces an especially vexing set of challenges that stem from its self-perception and historic grievance and humiliation, and its vision for a Sino-centric order in Asia as the return to a Middle Kingdom. The Communist Party is the key to the future of this trajectory, as it tends to promote international discord in order to create a need among the population of China for boldness and nationalism that only it can fill. These traits have yet to be reconciled with the reality of a region that already is crowded with numerous and powerful neighbors, buttressed by a deepening US offshore presence. China seeks to secure a more nuanced and constrained vision of navigational freedom and safety through the new maritime instruments, whereas the United States aims to maintain the current architecture. Beijing's usage of international law is a departure from the past. During the 1990s, China avoided participation in international institutions or agreements out of fear that they were merely platforms to criticize or restrict Beijing's freedom of action. Now, however, Rather than remaining on the sidelines, China is consciously working to shape international institutions and rules to promote its interests. Under China's sponsorship, for example, new East Asia institutions serve as alternatives to US-dominated organizations. China led creation of the Shanghai Cooperation Organization to cement closer relations along its western periphery. Russia is a member of the SCO. In the East, China promotes the use of the ASEAN Plus 3, China, Japan, and South Korea, as a forum for regional cooperation. What is the common denominator of both these institutions? China is the preponderant power, and the United States is not a member. The negotiation of the bilateral agreements with the United States for navigational safety arises within this context, which poses peril and promise. On the one hand, China is clearly intent on adaptation and even revision of the existing order of freedom of the seas that has persisted for the past 500 years. On the other hand, however, China's move toward negotiated agreements to achieve its perceived interests is an improvement over aggressive operational interceptions. In the words frequently, but wrongly, attributed to Sir Winston Churchill, jaw is always better than war. Thank you.
Thank you very much, Marco, for this effort, and also thank you to Professor James Graska for having offered to us this paper. Now, the floor is open. We have some minutes, 10, 15 maybe, for questions and debate. So I give the floor now to Professor John McNabb. No, there is a mistake in your please take the floor.
Yes, I found, Dr. Zhao, your comments were very, very interesting, particularly with regard to the question as to whether China considers the 9 lines, however many we're using nowadays, as internal waters or EEZ waters. And one of these is in the late 80s, when we started looking into this, we found that about 300 ships a day, this is the late 80s, 300 ships a day were going between the Spratly Islands and the mainland, Vietnam, China. And in fact, most of the shipping that was coming through through Egypt, through the canal, was actually going this direction, through the straits by Singapore and across through that path. And even the super tankers that were supposed to go through Indonesia, it turns out were actually going that same route through there. And this is most of the trade coming and going from Japan, a large proportion of the trade coming and going from Hawaii, and a large proportion coming and going from California. Now, you mentioned that most of the concern right now is about military transport, but you also mentioned that if there was a conflict, there would be inconvenience, would be severely understating it. We would be talking billions and billions of dollars in trade that would be stopped. So I'm wondering, I assume it must be much more now, but can you comment more on that side of it? What do you think this is? If it is internal waters, then I understand those boats could be boarded and so forth. And if it's EEZ, then there's more of a right-of-way, correct? Maybe you can comment.
Okay, we collect some other questions. Please, Mr. Grosero.
Thank you, Mr. Chairman. It seems that there is a perception that if you have a maritime delimitation issue, or if you have a overlapping claim of territory, then somehow it will hamper the freedom of navigations. If you look at the way Indonesia, Malaysia, and Singapore organize the cooperation in the Straits of Malacca and Singapore, it's very interesting, because In some parts of the straits, there is no maritime boundary. In Johor, between Indonesia and Malaysia, there is no maritime boundaries. There was a case of Petrobranca between Malaysia and Singapore, overlapping territory. There was no boundary, and the island's ownership was not clear. Some parts of the lower part of Straits of Malacca, between Indonesia and Malaysia, we have no maritime boundaries. Yet, these three countries able to establish a very sophisticated freedom of navigation mechanism called the TSS, Traffic Separation Scheme. We had a joint survey. We have worked with even the World Bank to establish what we call the Marine Electronic Highway. So it's not really the existence of dispute that hamper freedom of navigation. I think it's, I would say, the political will or the political courage, probably, of the countries involved in trying to put the international obligations and international above national interests, because I think this is the key. We have cooperative mechanism on freedom of navigation, safety of navigations. We even have a coordinated patrol between Indonesia, Malaysia, Singapore, without maritime boundaries in the Straits of Malacca. We managed to reduce piracy. And now the problem of piracy in the region goes up in South China Sea because there is no similar activity by country in South China Sea. So we have even a joint mechanism of funding Indonesia, Malaysia, Singapore, plus Japan. If there is an oil spill, we use this funding immediately to clean up. Then we go to London to file lawsuits, if we need to file lawsuits in London. But this mechanism is there. It's been there since 1978, and it's been very, very good mechanism referred by many countries. So I think it's our practice. It shows that the existence of or the non-existence of boundary, or the non-existence of ownership of island, or the existence of dispute does not necessarily mean it stops. So I think if Qs can go ahead, or other countries in the regions can also work on what we do with Indonesia, Malaysia, and Singapore, it would be great. Thank you.
Thank you for questions and comments. And for the first question from Joy, it's about, actually it's referred to the legal status of the 9-dash line, and whether it is internal waters or territorial sea or the EZ. And my simple answer is I don't know, because there's no official explanation from the Chinese side. And in 1995, and the Indonesia government sent a diplomatic note to the Chinese government asking to clarify the legal status of the 9-dash line, but there's no reply. The reply is very simple. The Chinese side said that there was no territorial dispute between China and Indonesia, but there's no any explanation about the 9-dash line. So to me, but in practice, and normal navigation of commercial vessels, the passing through the South China Sea are never hampered, and we can see there's no incident reported that any commercial vessel was arrested or detained by the Chinese side or something. But in my paper, I do mention some resource associated activities, like the oil leak, recent oil leak incident. And this is kind of a resource, and also a Reed Bank incident, and between China and the Philippines. But these are all these exploration vessels. They're moving around the South China Sea. So this is another matter. And for the second one is about delimitation. I agree with you. And of course, unsettled boundary may not hamper any navigation. And what I'm concerned about is whether these overlapping claims, once they could develop into tension, very high tension, even into a conflict, then there could be a hindrance to the normal navigation. And also I appreciate that you mentioned the Malaga Strait, and the Malaga Strait arrangement for the Malaga Strait is, and of course assisted heavily by the International Maritime Organization, and also is under the legal framework of straits used for international navigation. So it is quite well and also very efficient. And on the other hand, I would like to mention that Malaysia, Indonesia, and Singapore, they submit their disputes to the International Court of Justice. So this could be very recommendable and also should be learned by their neighbors, including China. Thank you.
If may I add something about this, because it was also a question that I would like to make to you about the value of 9-dash line, because we know that in international law, maps do not constitute titles. A map is not a title, and so far the 9-dash line is only a map. We do not have had any clarification about the real juridical value of this document. And this uncertainty, of course, does not help. You mentioned also about warships, the alternative between the prior notification or the authorization. So we have this sort of uncertainty that does not help. And also about navigational issues, overlapping claims. For example, the oil rig accident of last year, the statute of Triton Islands. We have to know if, for navigational interests, it is Vietnamese EEZ or territorial sea of China, because it is different for a ship, a third state ship, who is going to pass through this area, of course. There was another. Yes, please.
Thank you very much for the interesting presentations. My question would be that we've seen reactions from the coastal states in the area to the Chinese policies. We've also seen that the United States has reacted by way of these memoranda. And now, how about, do you see, what sort of trends or prospects you see for others, which are other states, basically parties to Law of the Sea Convention, reacting to these moves? Because as any party to the Law of the Sea Convention has certain objective interests and legal rights to freedom of navigation and all that. So they are basically in a position to react, because what we see going on in that area is also maybe to be seen in the prospect of lawmaking, because this is a state practice. There are different kind of memorandas and all that coming into place. So what do you see as the others in the international community as reacting to these developments? Are there any patterns, or what sort of ways you could maybe indicate that are good ways to react to these? Thank you.
There was another question. Yes, please.
Thank you, Professor Châu, for a very interesting speech. I have one question for you and one remark. My question is that how the activities of building islands in South China Sea affect the navigational rights of foreign states there. And my remark about the attempt to conduct a bilateral treaty between the U.S. and China concerning the freedom of navigation in the South China Sea. And for me, the sea zones in South China Sea have not been clarified yet. And if the US and China conducting a treaty concerning navigational rights there, admit that a disputed zone, it would be violating the rights of other states. And therefore, if there is any treaty concerning South China Sea, like Professor Anderson mentioned earlier, all the stakeholders should be included. And thank you very much.
Thank you for the questions and also comments from Professor Katati. And the first one is about a map does not confirm the title of territory. I agree with you. And but the map can be a kind of evidence if you submit the dispute to the International Court of Justice, and also according to the jurisprudence of the RCJ, if the map published by government, it has some legal weight vis-a-vis private maps. Second is about the oil rig incident is because Vietnam claimed that the oil rig is within the EEZ of Vietnam. And China said that the oil rig was located 70 miles, nautical miles, from the Paracel Islands. Currently, Paracel Islands are under control of China. So this is kind of dispute, and we cannot say that it is automatically it's Vietnam's easy rather than China's easy, pending the dispute, the settlement of dispute, and also the maritime boundary delimitation. And the second question is about what are the reactions from the international community, and there are a couple of ways, because if you have some like the communication through diplomatic notes between the states, and also there's a way to issue declarations under the Law of the Sea Convention, like regarding the military activities in the EEZ, and there are about 20 countries, a bit more than 20 countries. When they ratify in the Law of the Sea Convention, they send declarations to the United Nations. Then also other countries, they reacted, including like UK, United States, and the Netherlands, and Germany, and against the statements the other countries made regarding to the military activities. So this is a kind of counterbalance. Of course, the declaration made by the countries concerned are not regarded as a reservation to the relevant provisions of the convention, just the indication of their government position. And the third one is about what about the artificial island or land reclamation in the South China Sea by China affecting navigation rights. So far, there's no incident at all. So I don't think currently that there will be an issue. But with escalation and of the scale of the land reclamation, I'm not sure whether there will be something affected the navigation. And the U.S. As a non-party, because U.S. is not a party now to the convention, but the U.S. argues many of the provisions in the law of this convention are customary international law. So customary international law, then the U.S. certainly enjoys the rights and interests regarding to navigation. Thank you.
We have time maybe for one last question, if there is. If there is not, may I thank a lot Professor Zhu for, of course, his intervention and for participation to debate. of course, all the people who intervened, and Marco Benatar. And may I conclude with a quotation of Deng Xiaoping, when he was once questioned about the South China Sea, and he answered, "Put aside sovereignty disputes and work together for joint development." So maybe if countries try to follow this invitation of Deng Xiaoping, I think it should not be a bad thing. What do you think, Professor? Thank you very much.
Before concluding, a last administrative remark. There will be a walking lunch which will be served in the same room as we had our coffees in the mornings and at 10 o'clock. I propose, since all the speakers and all the chairs for this afternoon are present, that we will start at 2:15 sharp in order to be able to keep up and give every panel the time that it needs to wind up discussions. So we start here back at 2:15 sharp. See you then.